Hey, looks like we have everyone with us. That's great. Um, Mr. Shaw, I believe you represent the appellant in this matter. Am I correct?
Yes, Your Honor.
Did you wish to reserve any time for a rebuttal, counsel?
5 minutes, please, Your Honor.
Thank you so much. We are ready to begin, counsel.
Thank you, Your Honor. May it please the court. Good morning, James Michael Shaw Jr. With Butler, Weimmuller, Katz, Craig for the appellant State Farm Fire and Casualty Company. Your Honor, is on page 627 of the record is the court's order on motion for summary judgment. The court made 2 correct findings and respectfully to the trial court 1 error. The court correctly held that if the only question were, does the language of the policy as written provide coverage? The answer to that is a clear no. The policy language that this accident would be covered by an exclusion in the policy. The second question is, are we allowed to have that language in the policy? And the court correctly answered yes. Subsection 9 of 67.727 authorizes us to have that language in the policy. The third question is, did the insured validly waive that? And there's where the trial court committed an error. The statute says that if there is a form informing the insured of the provisions in the policy that is signed by a named insured, and that form is approved by the Office of Insurance Regulation, that creates a conclusive presumption that those exclusions in the policy were validly and knowingly accepted by on behalf of all insureds. And
so I have a question for you.
Yes, ma'am.
Sorry. We're dealing with the rejection of stacking coverage or the waiver of stacking coverage under subsection 9, correct?
Yes, Your Honor.
And we have a form that undisputedly was approved by the OIR. Am I right about that?
Correct, Your Honor.
No question about one syllable or one punctuation mark missing. It was approved and nobody's saying it deviated from the approved form.
That's correct, Your Honor.
And it was signed by named insured.
Correct.
And the statutory text says, if the form which informs the named insured on a form approved by the Office of the Limitations and that such coverage is alternative to stacked coverage, if it is signed by a named insured, it shall be conclusively presumed that there was an informed knowing acceptance of the limitations. That's what the statute says. So yes, we have the approved form and we have the signature. And it seems to me that there, under subsection 1, there are some more requirements for the rejection of UM altogether. And the form there is prescribed, right?
Yes, Your Honor.
But no form is prescribed. No specific text is prescribed for this waiver of stacking.
That's correct.
It's only required that the form be approved by the OIR.
That's the one and only requirement under the statute.
And it seemed, my read of what's gone on here is that the trial judge decided that the form was not adequate notice of the waiver, of the scope of this waiver. Do I have that right?
That's correct. The trial court proceeded to scrutinize the language of the form and not just the question of whether it was approved, which is the only inquiry authorized by the statute.
And I can't remember which of the orders this is in, but there's some suggestion by the trial court, is there not, in one of those orders that this form was insufficient to provide the requisite notice, the notice that subsection 9 requires of these limitations that inure if you reject stacking?
That was the trial court's rationale, yes.
Where in the record precisely can I find the trial court's criticism of this form as being not quite good enough?
I believe it's on page 627 of the record, Your Honor. Oh, wait, I might have that wrong. At 637, Your Honor. The court then proceeds to dissect the language of the form and compare it to the language of the policy and find.
Is the form part of the policy?
It is not. And on in the policy itself, on page 360 of the record and page 364 of the record, the policy itself explains what is and what isn't a part of the policy. It states in both of those places that the policy consists of the declarations page, the policy form, and any endorsements that apply. The selection rejection form is not on that list.
Is there any, I understand that the policy disclaims there, sets forth that that's all there is. Anything outside the policy is not part of the policy. Do you have any law on the issue of the waiver form not being part of the policy?
The only case I could not find a Florida case that addressed that question, Your Honor. The only case I ever found that did is a California case, Elliott v. Geico. It's cited in our reply brief. But the Elliott case looked at that question, and California has a similar statute that requires this to be disclosed to an insured in order for the insured to have permission to put these exclusions in the policy and have the courts give them effect. But the court held that that's not part of the policy itself.
Okay, well then, so that's but you don't have a Florida case.
There's no Florida case that I'm aware of.
I kind of hijacked you right out of the box. So let me let you get back to your knitting.
That's okay. Thank you, Your Honor. I think Your Honor's questions covered a lot of what I was going to say, which is that the statute provides a conclusive presumption that this policy language was knowingly accepted by the insured if an insured signs the form that was approved by the Office of Insurance Regulation. And here it's undisputed that the form was signed by Mr. Schnitz, one of the named insureds. It's also undisputed that the form was approved by the Office of Insurance Regulation, and the court's inquiry should have ended there.
The question I guess I have is on this document, this form. The trial judge's, I think it was the second order where he cited the Florida Constitution. He said it denied access to the courts, and therefore this conclusive presumption you would have denied to you. Let me ask you to make an assumption that the panel might conclude that this doesn't violate Article 1, Section 21. What remedy would be available to you in light of the stipulation that you have signed between the parties? Exactly what relief that are you able to get in light of that stipulation? My concern is that this may be tantamount to an advisory opinion.
I apologize.
You signed a stipulation to bring this case up, right?
Correct, Your Honor.
And you could have gone to trial and litigated whether or not the insured signed it and knew what he was doing. The only thing you were lacking evidentiary was a conclusive presumption. You elected not to do that and allowed a judgment to go forth. My concern is if we send this back saying, what, you were entitled to a conclusive presumption? Do we do that? Do we remand it for, how does that get around your stipulation?
Sure.
Did you waive it by not litigating it?
No, Your Honor. The stipulation was at that point, the court held that there was coverage, notwithstanding that it was excluded by the language of the policy. And at that point, we would have either had to litigate the liability of the uninsured motorist and the extent of Ms. Wilson's damages in order to get here. And neither of us wanted to incur that cost just to get here.
Let me make sure I understand what was in your stipulation. You stipulated to the policy limits, which I think here were $25,000.
$25,000, yes.
And you did that in order to get a final judgment that would be reviewable now, because under the holding, at least of the third DCA in Geico Perez 1, you couldn't have taken an appeal from the coverage determination.
That's correct. And to save the cost of litigating liability and damages, we stipulated
with the tortfeasor. You just wanted to skip the whole, we'll skip that and stipulate that if we don't win on coverage on plenary review, the 25 goes.
Right. Our request is that the court reverse the judgment for the plaintiff and remand with instructions to enter summary judgment for defendant based on this record, because the facts are undisputed that this was signed by an insured, that this form was approved by the Office of Insurance Regulation, and that our position is that should have been the end of the inquiry.
So your opponent makes a lot, spends a fair amount of time, and I'm going to ask your opponent some of these questions, but your opponent argues, spent some time arguing against LaRusso. My read of LaRusso is that if, for stacking purposes, or waiver of stacking. If you've got an OIR approved form signed by the insured, that's your conclusive presumption, and that's the end of it. Am I reading that correctly?
That's correct, Your Honor. And the Russo court went on to explain why that should be, because at the time in 1987, when subsection 9 was passed, the legislature had at that point 17 years worth of post-Mullis litigation to know that these waiver forms under subsection 1 end up getting litigated, that lawyers will parse the language in the form, and Geico Perez is a great example where the statute requires the text, please read carefully, and Geico v. Perez's form said, please read it carefully, and the extraneous it was enough that the form no longer counted. The legislature didn't want things like that, and that's why they created under subsection 9 a regime where it can be approved beforehand, and then the insurers are able to rely on them in assessing the amount of risk that they have taken on, and without worry that they've actually taken on more risk than they knew, because after an accident, the litigation of these forms are going to result in more coverage than the insurers ever knew that they were taking on.
I have another question for you about the remedy here. I was a little confused about State Farm's position regarding conclusive presumption, no conclusive presumption. In some cases, if the form is not sufficient to provide notice, although it's difficult to see how that would be the case here since it was approved by the OIR and there's no dispute about that, or there's some question regarding the validity or reliability of the insured's signature, the conclusive presumption may not attach, but the insurer, the parties are entitled to a trial on whether the insured knowingly accepted the limitations or knowingly waived. Did State Farm go all or nothing here and insist on the conclusive presumption, or did it preserve the possibility of going to trial on the insured's understanding of what the insured was getting? Because I think that's a lot of the insured's case, is they think they didn't know what they were buying, really.
The evidence is closed, and there's been no testimony one way or the other as to what the insured was subjectively thinking. The statute provides the conclusive presumption if the form is signed, and it was undisputed that the form was signed. So there's no question of whether that's really his signature or whether he was told that he was signing something else and it turned out to be this form. There's nothing like that.
And part of the reason I'm asking you the question is because, as I recall and understood the trial court's specific findings and expressions regarding this, a lot of it turned on the insured's knowledge or understanding, notwithstanding the signature on the OIR approved form. And I just wanted to sort of check what State Farm's position, what the record shows State Farm's position, whether it articulated a backup on wanting a trial, on knowing acceptance of the limitations.
No, there was no factual dispute as to that. The record is silent as to what the insured's subjective understanding was.
So you're saying there's no evidentiary predicate for the trial judge to make a finding regarding the insured's subjective knowledge. The only evidence of the insured's knowledge is the objective signature on the OIR approved form.
Yes, there's no question as to the text of the contract, and there's no question that it's the insured's signature on the form, and there's no question that the form was approved. That should be the end of the inquiry. The law doesn't require that both parties to a contract subjectively understand the language of the contract the same way. It's just that the contract says what the contract says. There's no question that applying the text of this contract, there would be no coverage here.
And you're saying, you're characterizing the form as a contract?
Yeah, as a matter of straight contract interpretation, the policy language still matters. And the policy language says there's no coverage here. The question is, does something in the statute mean that notwithstanding what the contract says, we have to give this coverage anyways? And to the extent that a statute does say that, it would be a statute in derogation of the common law and would have to be construed narrowly. There's nothing in the statute that would require us to provide coverage that's not set forth in the policy The statute simply says in order to include these provisions in the policy and have them given effect, the insured has to be informed of them. And if the insured signs the form that was approved by the Office of Insurance Regulation, then it's conclusively presumed that the form was accepted. But the form's not part of the contract. The policy is the contract.
Well, let me go back to and complete my circle as I think through this. The trial judge said he had a constitutional concern about the validity of the conclusive presumption and cited Article 1, Section 21. What if the trial court had cited the Supreme Court's case, was it of Recce, where there's a three-part test to determine whether or not under the Due Process Clause, a conclusive presumption violates the constitutional provision of due process? Ought we to acknowledge the trial judge's distant early warning system, if we will, and have that matter looked at on remand? Should we conclude that Article 21 and Article 1 is not a proper basis?
One doesn't need a remedy from the common law. The common law
Well, you know, if the conclusive presumption that the legislature has conferred violates the Due Process Clause, then you go back to proving it up in court. And I think Judge LeBret mentioned you had an opportunity to do that, and rather you stipulated. So if that conclusive presumption fails as a matter of due process, what relief would we then grant? I think the case would be over, wouldn't it?
If the conclusive presumption fails as a matter, well, first off, it doesn't fail as a matter of due process. That's the Liberty versus Ledford case, that as long as the insured has an opportunity to argue fraud or trickery or artifice, that the conclusive presumption is allowable under the law. But in a hypothetical world where the conclusive presumption does not apply, then I suppose we're off the map.
Then you would be calling him as a witness and doing it without a conclusive presumption to see what a juror might conclude or the panel might conclude. Because, you know, in Recce, which came out in '97, they said there's a three-part test to find out if these things, you know, these irrebuttable conclusive presumptions pass constitutional muster. But I think they're doing it under the Due Process Clause. I'm concerned because it wasn't preserved, because it wasn't the argument that was made, apparently by the trial judge. On the other hand, having occupied that seat before, sometimes, you know, your system is going off, and I wonder, do we need to give the judge any credence for, you know, alerting that there may be a problem? The time that I'm consuming from your 15, don't worry, I'll make up for you. That's one advantage of being center chair.
Thank you, Your Honor. The constitutional issues were not argued at all. That was something that the court came up with sua sponte. But in order to even get to that question, there has to be a right that existed in 1968 when the Constitution was adopted, and this statute wasn't passed until 1987. In 1968 and
do you have a right to require someone to prove their case?
When the issue is applying the plain language of the policy, that's the common law. So there's a remedy isn't needed from that.
I'm not saying that this would win. I'm just saying, do we need to have it addressed? I mean, I'm concerned that the judge may have put a fingertip close to the right concern. Whether or not it's valid or not, I don't know yet, because I've not researched it or briefed it, nor were you able to brief it. And that's my concern, that it wasn't preserved. Should we consider that on a remand or not, I guess, is the nuts of the question.
If the court concludes that there's something to the constitutional access to courts argument and remands the case, I suppose the court would have to, because we're off the map now, that wasn't something that was briefed in the trial court.
I'm not certain that Article 1, Section 21 is the proper vehicle, and that's why I was asking these lines. And I don't want to take any more of your time. I'm going to stop it here. You're at your 15 about 4 minutes ago.
Okay.
Do you want to reserve your time, sir?
I'd reserve the rest of my time. Thank you, Your Honor.
Thank you so much for bearing with me. I appreciate it. Mr. Bolduc, in order to make sure everybody's the same, you'll have 4 minutes extra too.
Thank you, Your Honor. And may it please the court. I respectfully, I agree with the interpretation that If a form is signed, if these selection forms are signed, then you are held to the presumption that you've accepted the limitations as described on the form. I disagree that the selection form at issue describes or has anything similar to what is actually included in the policy. If we look at the actual statutory language, it does say, there's an informed knowing acceptance of such limitations, which is referring to the form that was signed. So as the trial court correctly interpreted that a reasonable reading of this form would lead the insured to believe, given our facts, that she actually was entitled to coverage in this case.
So I'm going to interrupt you because I think you probably know where we're going here, and you all briefed it. Isn't what you persuaded, what the trial judge did, and you're arguing we should affirm, that the trial judge could essentially override the OIR's blessing of this form, which says, and I'm looking in the middle of the page, the non-stacking form of coverage is subject to, and it lists out the 3 conditions, one of which is no coverage under the circumstance that exists here. And so your argument necessarily puts the trial judge in a position of overriding the statutory text that says, if this form is approved by the OIR, and we all agree that it was approved by the OIR, then it is sufficient to notify the insured of the limitations on non-stacking coverage.
Yes, Your Honor. If the trial court has to give deference to the administrative agency. But
well, this isn't a deference to the administrative agency. This is deference to the legislature that prescribed the vehicle by which this form would become a conclusive presumption if signed by the insured, and that is if the OIR approves a text. We're not deferring to the OIR. We're deferring to what the legislature said the OIR could do and then did.
Yes, but we are prescribing to the OIR's, basically, you're correct. However,
this is not a Chevron deference situation. It's a question of whether we respect the legislature's directive that once this form is approved by the OIR and signed by the insured, it's conclusive. It's presumed that the insured understood the limitations on the coverage.
The limitations.
And your argument necessarily requires us to deviate from that statutory mandate.
My argument requires us to review the form that is approved. And again, if there's nothing saying that the court necessarily has to even override the form in our situation. It has to provide whether the form sufficiently describes the cover or the limitations that is trying to be held to my client. So again, even in the LaRusso case, as I mentioned, there was 3 findings. Was the form signed? Was the form approved by the OIR? And did the form explain the limitations of coverage?
Well, let's look at the statutory text, because I'm a little hung up on this text of this statute that says, if the form approved by the OIR is signed by a name insured, and then this is a quote from the statute, it shall be conclusively presumed that there was an informed knowing acceptance of such limitations. And the limitations are the limitation that your client is now saying doesn't apply because the form was insufficiently clear. Am I right?
I think that it's of such limitations as the form provides. Now, essentially, State Farm could have written this form and changed substantially the exclusion, which they did, to include all insureds instead of the injured person, which is what they wrote on the form.
Well, wait, you're saying that the limitations, the statute authorizes, the first part of subsection 9 authorizes insurers to offer non-stacked coverage, which include the limitations that are outlined at A through D, right? And that means they can issue a policy that has those exclusions. And in connection with that offer, says the statute, in the second paragraph after subparagraph E, insurers shall inform the named insured on a form approved by the office of the limitations imposed under this subsection. And that coverage is an alternative to those. And if that form is approved by the OIR, that's the end, and signed by the insured, that's the end of it. So it's not that the OIR was going to review the policy or that the form somehow would supplant the policy, is it?
No, it's that the form has to describe the limitations of the policy, which it does not.
Well, isn't that what the OIR would have reviewed the form for? I mean, we don't have a record on that, but presumably they were reviewing it for something other than just the font and type style.
I believe they were reviewing it for its congruity with the statute, but there was nothing in the statute that necessarily requires the State Farm to write down exactly the limitations as described in the statute, which they did not. They wrote an exclusion that allows this, that basically is completely different from what is on the what is on the selection form. So I agree, it does give 5 limitations that are allowed to be excluded in non-stacking coverage. And another argument I have is that there's no, as it operates in their policy, there's no situation here that would actually apply to our insured, and so that, you know, the exclusion actually is beyond what's allowable by the statute. But but to this argument at hand, the form can only give informed consent of knowing acceptance of what they're actually reading and signing. And so if what is provided, and again, I'm not sure what the exact you know, what exactly is done when the OIR reviews these forms. I'm presuming they look at it and they say this is statutorily okay, which it was, and then they approve it. And then it's State Farm's job to make sure that they write policies and exclusions that match the form and match the statute. You can't, the court absolutely has authority to override that, except in situations where in the exclusion, the insurer has overridden or gone beyond what is allowable by the statute.
Well, let's talk about what the insurer did in this policy. If I'm not mistaken, the policy text says there is no coverage for an insured who sustains bodily injury while occupying a vehicle owned by you or a resident relative if it's not your car. We know that Ms. Wilson is an insured. Mr. Schnitz is a you. The motorcycle was owned by him, and it doesn't fall within the definition of your car. Doesn't that text exclude uninsured motorist coverage on these facts?
It does, but that text, when actually defined, in essence says that you are not allowed to basically ride a vehicle that you don't own and that isn't owned by you or any of your resident relatives, if that happens to be owned by another insured. The statute language reads essentially you can only occupy a vehicle if you can only get coverage for a vehicle you're occupying as long as you don't own it, it's not owned by you or your insured, not owned by you or your resident relatives. In that situation, you'd be entitled to coverage. It actually says, you know, the injured person is occupying a motor vehicle not owned by him, her, or any family member, that injured person is entitled to the highest limits of coverage provided by any policy that they're named insured on. It also says, again, and State Farm would rely on D, I believe, that the uninsured motorist coverage provided by a policy does not apply to the named insured or family members residing in his or her household who are injured while occupying a vehicle owned by such insureds. So again, if you're injured and you're the named insured, you know, if you're riding a vehicle that you don't own or isn't owned by any of your resident relatives, you're entitled to coverage. And the exclusion in this case goes beyond that and says not only in that situation are you not entitled to coverage, but you're not entitled to coverage if there's another person that we listed as a named insured on the policy who you have no connection to other than that they live in your house. And if you're a passenger on that vehicle, then you're excluded coverage. There's no exclusion like that listed in subsection 9. I'd also, again, I made an argument.
That what you're talking about there, just so I can keep track of how it was briefed, is the argument that Schnitz, the first named insured, could theoretically have availed himself of coverage. Am I
Well,
right?
It's the argument that, yeah,
This is like your discrimination argument, right?
that's part of the discrimination argument as well, is that, there's nowhere on here that says you can limit coverage to a person just because they're the second named first.
Well, I'm going to ask it another way. State Farm under the statute could have excluded coverage to Schnitz and to Wilson under this exclusion, but it chose to extend, or at least the policy text enables it to extend the coverage to Schnitz as the first named insured. Is that accurate?
I think we're mixing two of my arguments together. The first is that the statute only allows you to exclude coverage when you are riding a vehicle that you own or that your family members own, that you or those resident relatives chose not to put on the policy. That's one situation where you can exclude coverage, which doesn't apply to Mrs. Wilson. Then there's another argument that there's also not a provision on here that allows you to discriminate between two class 1 insureds simply because they're listed second on the vehicle, on the policy. Yes, they could have written the exclusion to not also include Mr. Schnitz, which would have removed that argument from the table. But they did. They wrote an exclusion that actually only applies to the second person listed. So it says so
they gave Mr. Schnitz more coverage than the statute required, and they gave Ms. Wilson only what the statute required.
They gave Ms. Wilson less than what the statute allows.
How did she get less than what the statute allows?
Because nowhere in the statute, again, she is a named insured on the policy. She did not own the motorcycle. She had no ownership interest whatsoever in the motorcycle. And neither did any family member that she had, or any especially a resident relative that she had owned the vehicle. The only person who owned that motorcycle was someone who was not related to her. And she was listed as, second named insured on this policy, but they weren't related. And again, the only situation contemplated by the statute is when you're riding a vehicle that you or your resident relative own and you chose not to put on the policy. That's not the case. So go ahead.
I'm stuck on subsection D of the statute that says the coverage provided by the policy doesn't apply to the named insured. Ms. Wilson was one of those. Injured while occupying any vehicle owned by such insureds. Mr. Schnitz was one of those. He owned the motorcycle, for which uninsured motorist coverage was not purchased. Uninsured motorist coverage was not purchased for the motorcycle.
Well, and again, Your Honor, I disagree with your interpretation of subsection B. It says it doesn't apply to the named insured or resident relative who is residing in their household while occupying in a vehicle owned by such insureds, which is again referring to the individual who's injured in the accident.
You say that the reference vehicle owned by such insureds, plural,
correct,
is referring to the vehicle that had to be owned. It couldn't be owned by one or the other. It had to be owned by both. Is that your argument?
No, my argument is that it's referring, even though it says insureds, it's referring to the named insured or family members residing in his or her household.
Schnitz was one of the named insureds, though.
He wasn't the insured that was injured. The named insured who is injured is what is actually being referred to here when they talk about the insureds, that person or their family members.
So your argument is that the phrase vehicle owned by such insureds refers to the insured that suffered injury?
Or their family members residing in
because the first phrase, which is the coverage provided by this policy, does not apply to the named insured or family members, but here named insured is enough because it would be Wilson or Schnitz, injured while occupying any vehicle owned by such insureds. So you're saying that we should read the named insured text, which does refer to the person that was injured, to be the same in the second phrase, vehicle owned by insureds. It must mean the context of the description for insureds is only the one that was injured.
Correct. It's
That's your argument?
It's referring to the description as provided previously, and that's in subsection D, which is the singular term named insured or their family members who are injured. It doesn't say anything about all named insureds. It could have listed the first portion. It could have listed the plural version, but it didn't. And again, it just wouldn't have made sense for them to require somebody who has no ownership interest or control over a vehicle to insure that vehicle. She simply didn't have any insurable.
Well, the UM coverage doesn't follow the vehicle, though. It follows the insured, doesn't it?
Correct.
So it doesn't matter whether the insured has any insurable interest in the non-owned vehicle. It matters whether they purchase the coverage, stacking or not.
It matters if, I believe it matters if they are able to even insure a vehicle. So
but UM, I mean, part of the reason for UM is if you have an accident with somebody who has no insurance.
Mhm.
So the insurance, the insured status of the motorcycle is, to me, largely irrelevant, other than the fact that it wasn't insured.
Well, I mean, it's relevant because in subsection D, it talks about specifically, when coverage is not purchased for that vehicle. So,
right. But her status as an insured turns on whether she purchased stacking or some other form of coverage or rejected stacking altogether, whatever. She had UM, she chose to take a lesser form by rejecting stacking. And that status followed her to whatever vehicle she was going to be in, non-stacked.
yes, correct.
Okay. I just want to make sure I understood exactly.
And again, Your Honor, I guess further to the notice issue, the trial court relied heavily on the fact that the form can only extend notice as far as what the conclusive presumption of informed acceptance. Really, it has the ability. It refers to the ability of the form itself to sufficiently describe what the limitations that are being accepted. And I think if a plain reading of that form necessitates you to believe that it's talking about the injured person's car, not any other insured's car that potentially could have owned a vehicle on the policy. And so, again, my interpretation, and I believe the trial court's interpretation was correct, that yes, she was accepting those terms as written on the form, not as what was written elsewhere in the policy. And again, State Farm could have corrected that by just adding in other insureds or all.
They couldn't correct it without having the OIR review it and approve it. And what they have is what the OIR approved. You agree with that, right?
What they have is what the OIR approved.
And if they made any change to what the OIR approved, it would then that would be your challenge, right? I mean, if State Farm put the word "it" in between this, that, and the other thing in this form, that renders it subject to attack and the conclusive presumption no longer available.
My argument would be in that situation is that they should have written a form that actually matched their policy and had that form approved by the OIR. They had the form approved.
So doesn't that take us to then your client's real redress should have been to go under the primary administrative jurisdiction under Rome, et cetera, and go see the OIR and redress her grievance with the deficiency in the form that the OIR approved and tell them what they should have done before she brought this to the court? Isn't this within, if that's the core nut of her position, it seems like something that should go to the OIR.
I don't believe that the OIR necessarily made a mistake in approving the form. Again, because the form is fine when you compare it to the statute. But the policy that's written doesn't compared to the form or to the statute. I mean, the policy, again, is completely different, and State Farm got the form approved. And again, if you read the form in our situation, we'd be fine. So I believe the redress, as we've seen in other cases, that you're allowed to go to the courts and petition whether the form sufficiently described the exclusions.
Help me find, I want to know a case where the form was approved by the OIR. The text of the form that was approved by the OIR is exactly the form that was signed by the insured. There was no dispute regarding the insured signature, and an appellate court reviewed the language of the form to reach the conclusion that it was insufficient, as you're advocating we should do here. Is there a case for that? Because I haven't seen one.
There's a case that I didn't. So when we had a case previously, Your Honor, it was a case with the second district. It was I have the citation. It was a PCA approved. It was a PCA case.
I don't think that's really going to help us.
Yeah, again, I'll tell you though,
it has no presidential authority and it hasn't been cited. So Mr. Shaw doesn't know anything about it yet. So we will need to leave that out there.
correct.
Is there a published opinion where an appellate court invalidated, for purposes of providing more coverage that wasn't purchased, invalidated an OIR approved form in the precise form approved by the OIR that was signed by the insured, and some appellate court in the state of Florida wrote that they were empowered to invalidate that form for purposes of the coverage limitations that the form prescribed and that the insured otherwise would be conclusively presumed to have accepted? Is that case out there? Because if it is,
the Vero case, they did that.
In what case?
The Vero case I cited, second district. What they did was they reviewed this exclusion that was written to exclude Class 2 insureds entirely. It was a non-stacking form of coverage that was purchased.
Did they? I want to be real precise here. Did the Vero case analyze the availability of coverage based on the OIR approved form or based on some other aspect of the policy text? I read Vero, it's been a couple of weeks, but I didn't read Vero for the proposition that we're empowered to second guess the OIR under this statutory mandate.
I read Vero that, an OIR approved selection form was signed and it contained an exclusion that was found in the policy, but the exclusion was not permitted and not allowable by subsection 9. And so the court had the authority to invalidate the exclusion, and the form. Again, the form contained the exclusion that was found in the policy in that case. But again, just because the OIR approved it did not preclude the court from then going and reviewing that, whether or not the selection form and the policy were in violation of the statute.
You have about 30 seconds left. I'm sure you'll thank me for the extra time later, right?
Thank you, Ron. Again, the Los Olas case that I cited specifically says that we're, basically you're allowed to review approved. Again, it's not a case, but it does stand for that principle, as well as some of the other cases that I did cite. Again, Your Honor, I asked the court to affirm the holding of the lower court, and finding that the form did not sufficiently contain this limitation as provided, and therefore could not have informed my client of the policy limitations. Thank you.
Thank you, counsel. Okay, let me turn off this timer. Okay, we are ready for rebuttal now, Mr. Shaw.
Thank you, Your Honor. On the Vero case was not a stacking versus non-stacking form under a subsection 9 case. The Vero case, they had it appears to me from my reading that they had the stacking form of coverage. There was a comment in Vero that the exclusion that was present in that policy language would not have been allowed even by subsection 9. That's not the case that we have here. Here, our language is expressly permitted by subsections 9B and 9D.
So you're saying that the proposition for which he cites Vero is essentially dicta in Vero? Is that your?
It's not dicta, it's just a different holding that's not this question. The question in the policy in Vero tried to, it was a corporate named insured, and it tried to exclude all class 2 insureds, people who aren't named insureds, but they're in an insured vehicle. It tried to exclude all of them except for the corporate officers and their family members. And under subsection 1, under Mullis, you can't do that. It did have a sentence that said in Vero that you couldn't do that under subsection 9 either. But the issue there was that the policy language wasn't allowed by the statute. Here, our policy language is allowed by the statute. So Vero just didn't address this question at all. Vero didn't look at the language of the form and scrutinize it and decide that because of something, this would have been allowed, but it's not allowed because of something in the form. That's not an issue that was decided in Vero. Vero tried to categorically exclude class 2 insureds who weren't family members or of corporate officers or corporate officers themselves. And the court said that you can't do that. It doesn't stand for some global proposition that discrimination between insureds is not allowed, which is the proposition for which the appellee cited it. That word discrimination, we don't like it because it makes us think of sex discrimination or race discrimination, but every insurance policy discriminates between people who are insured and people who are not. And the court correctly pointed out in Universal Underwriters v. Morrison, a policy is allowed to give more than what is the statutory minimum. But the policy language still matters. And the language of this policy excludes coverage. The question is there something in the statute that says, notwithstanding the policy language, you still have to provide this coverage, even if the language of the policy says not? It doesn't say that.
Point me to the precise record pages. I think you did it at the beginning, but I want to make sure I have a note on it, where you say the policy text that supports this exclusion. And I'm not clear, to be honest, whether you're relying on the exclusion that's in the statute at C and D, or one or the other, or both of those.
I'm relying on the exclusion in the policy. It's the policy text that matters, not the statute text. But
well, it has to be authorized by the statute. So
correct.
Point me to where the policy text is that in compliance with the statute, subsection C and or D makes this exclusion.
The policy text is at page 47 of the record, and page 637 of the record is where the court states that it agrees that if the only question were the policy text, that there wouldn't be coverage. It also states that the court agrees that that policy text is authorized by the statute. The court just then goes on to address something that the statute doesn't authorize, which is to do what LaRusso says, what the statute says doesn't authorize. It goes off into a statutory analysis based on statutory text that isn't there. The only thing the statute authorizes is the question of, is there a signed form and was it approved by the OIR? And there's a footnote in LaRusso that says any other conclusion would result in the potential litigation of forms rejecting uninsured motorist coverage in every case in which they are present. And here we are litigating that. I only have a little bit of time left, and I do want to finish answering Nueva's question. The constitutional law question was not raised by the plaintiff below, so it is waived. The court should not remand the case to the trial court for the plaintiff to raise an issue that wasn't raised before. What this court should do is reverse the judgment for the plaintiff and remand the case to the trial court with instructions to enter summary judgment for State Farm.
You would want us to reverse that portion of the trial court's order that found the form violating the access to court's provision and affirm that part that says there's no coverage.
Correct.
The part where he agreed with you all.
Correct, because the inquiry should have stopped at the conclusive presumption that there was a signed form and that the form was approved by the Office of Insurance Regulation. The big picture is they could have purchased the stacking coverage for $25 more. And the only point of the form is it's the equivalent of that bubble on your screen that says, are you sure you want to do this? And that the insured is given that moment to reconsider, maybe this coverage is important enough to pay the $25, or sign this form and save the money and have coverage that covers you only on this vehicle with a few exceptions. That's what Mr. Schnitz did. And the language of the policy holds that that coverage is excluded in this situation. It was within their power to purchase the higher coverage, but they didn't.
I thank you, counsel. I thank you both. Appreciate your candid responses to our questions and your level of preparation. That will conclude our 9:30 session. So I guess I need to let you know as lawyers that it's time to go ahead to leave the meeting room, but if you wish to, you're welcome to watch our remaining 2 cases. May not get you enough billable hours, but in case you find this interesting, you're welcome to stay. With regard to the panel members, we're going to take about, let's see, what time is it now? 11:41, say about 11:51 or 15 minutes? 10 or 15, what would you like? You're muted, Judge Vellante. Still muted.
No